who is the election commission to now determine?
Let's say you set aside the Sibal order.
No,
They say that okay, today you go for an organization election.
we'll come to that symbol later. No, not even on that. At the moment, I'm dealing with what the election commission has done. But apropos what your lordship put to me, let me answer.
Why, Mr. Sibal, we need to decide these questions not purely as legal issues. We have to see the ground reality.
I agree.
Working of the political party, as you rightly indicated yesterday.
Shinde becomes the chief minister on 30th of June. Right? No, let's not forget that fact. On the basis of the legislative strength alone, without reference to the party, he is made the chief minister. What will happen? If you are looking at ground realities, what will happen? What happens when you become a chief minister? Naturally, people will come to you. So you mustn't also forget that ground reality.
That inflow of primary members or other office bearers was only by virtue of the office.
That's right, because he became the chief minister. You illegally appoint him as chief minister. Then you say, no, now so many people have come. Now look at our strength. So that's the other ground reality. The point is, Malaj, who is the election commission to now determine as to at which level, how many people and on which post, who is going to be elected? And Malaj, your lordships may realize there is no dispute pending with the election commission on any of this. Election commission is deciding a para 15 dispute. There is no dispute in the election commission to any of the provisions of this constitution or the elections or nominations made. There is no complaint of any authoritative exercise of power. None of it. And the commission says that this is an autocratic constitution. I mean, it's because the commission wants to come to a particular conclusion, and it's no way to come to that conclusion unless you exclude the constitution, exclude the organization, and then say, I'm left with the legislative party and they have a majority, and therefore I'll give them the symbol. So you predetermine your end, and then you manipulate the logic for it, contrary to the very exercise in the paragraph 15.
The symbol is a different thing. That relates to the party.
Yes.
Split has to be decided under the tension.
Correct. No. I'm talking about paragraph 15.
Split in the parliamentary.
Yeah. I'm not on that. I'm on paragraph.
The legislative party and split in the party.
So, but if paragraph 15 doesn't talk of, then the rest doesn't arise.
It has become irrelevant.
So that's my fundamental point.
But your affidavits show that there was a substantial backing of the rival group in the organization and primary membership.
Not in the organization, but that's also afterwards. Please.
That is where we are putting this question.
Yes.
This afterward fact, whether it can be taken in.
Take it then. Even then, I'm far ahead.
Primary membership of 4 lakh Shiv Sainiks are with the rival.
We had 19 lakhs.
We are not on that question. Now you are jumping ship. First, we see whether there is a split, right? The split can originate in the legislative party, but its crack can percolate into the organization. Primary membership.
Let me answer that. No, but the split can never arise in the legislative party as a party split, as a proposition of law. Can never arise. That's been decided by the Constitution bench.
The Constitution bench says that the test of a split cannot be restricted to a split in the legislative party. But it never says that a split in the legislative party, if it gets reflected in the organization and the primary membership, it needs to be...
No, I'm sorry, Manas.
Because
I'm sorry.
It's like the epicenter of...
Forget about what the Constitution bench says. Read para 15. Just look at para 15.
Para 15
doesn't talk about legislature.
That logic we have to take into consideration after hearing the respondents here. But we have followed your submission it appears to require further scrutiny. It is logic. You are making a strong case.
No, that's all right, I'm only saying.
But
only saying.
What we are seeing is, Mr. Sibal, if we trouble you.
Yes, please.
List of dates.
Yes.
You see, in your list of dates, you have yourself said that affidavits were filed.
Yes, yes, of course.
Affidavits show
Of course.
it's not that Mr. Shinde Group.
And, I showed it myself to your lordship the other day.
So we wanted clarity there.
Yes, certainly.
So when Raj Prabharis,
Yeah, yeah.
he has 11 Raj Prabharis,
Correct.
right? Office bearer organization, he does not. But
Right.
Raj Prabhari is a part of the party's
Well, but
structure.
yes.
It's not that it's outside the Shiv Sena party
Give me the
structure.
structure.
Then it has, more importantly, when we see a party, it's not office bearers. It's the primary member.
Correct, correct,
Primary member, 4,48,000.
correct.
So how can in this situation, when you have a hierarchy,
You're right.
and in a hierarchy there is a overlap
Right.
with, or rather a subset of the
Right.
legislative party,
Right.
a fissure develops in the legislative party and proceeds into the primary membership.
All right. Yes.
In this situation,
How should you look at it?
it will be required by the commission to see
Right.
whether this will constitute a
All right.
rival
Well,
group for the symbol.
I've taken your point. Let me respond to it. Whereas when the split, just
Let's say you set aside the symbol order.
no,
They say that, okay, today you go for an organization election.
we'll come to that symbol later. No, not even on that. At the moment, I'm dealing with what the Election Commission has done. But apropos what your lordship put to me, let me answer.
Why, Mr. Sibal, we need to decide these questions not purely as legal issues. We have to see the ground reality.
I agree.
Working of the political party, as you rightly indicated yesterday, when the section 28A says that they will follow the ideals of democracy, socialism, and secularism, etc. Today, it is the ideals in the constitution and the administration of the state
Sure, Madam.
and the society.
Sure.
So they cannot have a slogan of secession because it goes against the security of the
Right,
state and the sovereignty of the
Right.
state. They cannot have a party which
Right.
says we will tomorrow elected make India an autocracy.
Yeah.
We will do away with democracy.
Right.
So that is the ideals that he has to hold.
Correct.
And that cannot be completely reflected to have an complete democracy in the structure. There should be semblance of representativeness, etc.
That's right.
This point is well taken.
Yes.
Similarly, when you see the split or a rival group, it's an evolving question.
Yes. Yes.
It's an evolving question.
No, I
As
agree.
you said, look at the Samajwadi Party case. If we saw the Samajwadi Party case in 2012, 13, 14, big split. By 18, 19, the split there is no split again. There is a merger. So in this situation, the commission would have taken into consideration the existence of the rival group percolating into the party membership.
That also he didn't do.
That is one thing. That is correct. That is something whether we can supply this reason when that reason was not there.
That's right. Nominal.
Mohinder Singh Gill principle.
Yes. A point.
You cannot. But the thing is, a material which is relevant in support of a conclusion, if not disputed, it can be a good reason to sustain, even if that is not.
No, but in any case, he says, I won't look at the organization because I'm only looking at the legislative.
It is the next question.
That's right. No, but forget that. Let me answer your lordship's question.
Rival group, perhaps the commission reasoning requires review.
Yes. But let's leave that out.
Totality of facts, it would be very difficult to ignore the fact that a group which actually may be born in the legislative halls did not have a resonance in the parties.
I will take your lordship's observations to be the starting point of the law, but let me answer it. Your lordship said to me, as I understand, there may be a split in the legislative wing, but you can't just look at that. You have to look at the ground reality as it evolves.
The told.
right? And at the, by the time when the petition is filed before the commission on 19th July,
There is a great support to that.
right. Let me assume that. Now, Malas, what are the facts? Just note one fact. Shivnath Shinde becomes the chief minister on 30th of June. Right? No, let's not forget that fact. On the basis of the legislative strength alone, without reference to the party, he is made the chief minister. What will happen? If you are looking at ground realities, what will happen?
That is where Subhas Desai says that those were all.
Yeah, but what happens when you become a chief minister? Naturally people will come to you. So you mustn't also forget that ground reality.
That inflow of primary members or other office bearers was only by virtue of the office.
That's right, because he became the chief minister. You illegally appoint him as chief minister. Then you say, no, now so many people have come. Now look at our strength. So that's the other ground reality.
If all these factors, then you may not be right in saying the commission jurisdiction at the threshold itself is not there. Approach may be wrong. If the commission doesn't have a threshold jurisdiction, then no question can be gone in.
I agree.
Right?
That's my submission, Mother.
If the jurisdiction is there and that jurisdiction is erroneously exercised, approach is contrary to the settled principle, then it's a different issue. But you want to argue that commission doesn't have jurisdiction at all.
No. I say on the date when the commission exercises its powers under para 15, there should be a split in the party. On 19 July, what does he say? He goes only two documents. Well, kindly just look at, he only has two documents on record.
Right.
One is the legislative strength, and two is a meeting held. Now just look at that.
On facts of this case.
I'm talking about this case.
No, this is on facts of this case.
Yeah.
We are on the general principle of competence and jurisdiction of the commission. That on the date, as you rightly say, on the date when question of 15 arises,
Yes.
the commission will have to examine whether there is a split in party.
That's correct. That's all.
And when you examine this question,
Yes.
it is obvious that all collateral issues will also be gone in.
Correct. So, Malas, whatever for example, I'll give you a lecture. On that day, he said, I'm sorry.
People, we are saying this is, come to paragraph 6 of the commission's order.
Yeah.
On 8/8/2022, the commission received documents from Sri Chirag Shah, learned counsel for petitioner, whereby it is.
That's after 19 July, Malas.
On 22nd, in compliance with the commission direction, letter dated 22/7/22, he files documents.
8th August.
Application petitioner internally has submitted affidavits supporting 12 out of 19.
That's 8th August, Malas.
40 MLAs and further submitted a chart showing support for the petitioner in the organizational.
I don't dispute. That's 8th of August. Malas, please, let's be clear on some basic facts.
This is the question we are putting to you. Will it not, when the commission decides on the symbol, is the time frame struck on the date of the application?
No.
Or the evolving subsequent events which take place?
No. If there is a prima facie split in the party, evolving events will take over. There's no issue on that, Malas. What my lord is putting to me is absolutely right. If the prima facie case is made out that there is a split in the party, they will evolve. And at the time of the decision, Malas, a decision will be taken as to who is entitled to the symbol. I am not on that stage, Malas. Of course, on 8th August, thereafter, there will be documents filed. But what was the document available with the commission on the 19th of July? Do you need a split on 19th July, Malas? Let's be clear on that. What are the documents? I'll show you. One is the legislative, Malas. And what is the other document? Only one other. 18th July. It's very interesting.
They are filing the application on 18th of July.
19th.
19th.
And they show a document of 18th July and the majority members of the legislature. Correct? Now see the.
You have already argued.
No, see 18th July. 398. This is very interesting. Myself, Malas, can a split happen afterwards? Or will it happen on the date when he files the petition under paragraph 15? It's a question that your lordships might like to consider.
No, that we understood your argument.
So if the split happens on that day, you have to look at that day. What is the evidence?
The argument is there must be some semblance
Yes.
of support beyond the legislative party
Correct.
to this split
Yeah.
at the time when he applies for the silver.
That's all.
Then he can add on fact.
Yeah, no problem.
This is your argument.
This is my, and let's kindly see what is that document? I'm
The
sorry.
split is to be seen on the cutoff date of 15.
That's right. Now, if you look at that, he has only legislative party, the rest is one document. Just see that. That document, even the commission doesn't take it into account. What is that document? Translation of minutes of the Shiv Sena Pratinidhi Sabha. Who are the people present here? Page 297 people. This is the Pratinidhi Sabha, which has all those hundreds and of members. No notice to anybody. He gives this document. So could the commission have come to the conclusion, and on this day, was there a split in the party? But I take your lordship's point. If prima facie the slippage there, it's an evolving situation. And then, Mullahs, whoever ultimately has a larger strength both in the organizational structure and the
That is the
legislature.
same situation which you argued in the Samajwadi case.
That's right.
The argument against Mr. Akhilesh Yadav was that his organization, he had called us organizational
Convention, yes.
convention,
Yes.
which correctly understood by the commission was evidence of split outside the halls of the
On that day.
Legislative Assembly.
Yes.
And there the argument against that was it was not as per the party constitution.
Yes. Yes.
And the decision was we are not looking into the legality of
Exactly.
convention, but
Exactly.
the factum of support.
Correct. And here is none.
Of support was there.
Here was none. Here it is none.
Apply that ratio, then Pratinidhi Sabha, whether notice was given or not, if that document is genuine,
It is not genuine. Even just see, look at the document. You see for yourself, Mullahs. If your judicial mind, Mullahs, and the kind of mind that your lordships have, will come to the.
We understand, and you have a very strong, compelling cases because that document has not been considered by the
Commission
tribunal,
itself.
by the commission.
Itself. Because it's ex facia, it's something that.
View whether we can look into that document.
So whether we are left only with the legislative party, then how will para 15 jurisdiction be exercised? So, Mullahs, but your lordship is right. Once prima facie, of course, there's a split will.
It can evolve. It
No
can
doubt
evolve.
about it. I agree. I mean, I have no dispute on that proposition. We have had several petitions which I have myself argued both in the commission and here that evolving situation.
Take a pragmatic view here.
Yes, it's correct.
We are dealing with
With correct.
living democratic
Absolutely.
aspirations. We cannot.
I don't know how democratic it is, but we are certainly living in
Everything.
aspirational India. Mullahs.
Everything is flawed.
Living in aspirational India. So, Mullahs, anyway, so have a look, Mullahs. I would suggest you have a look at this document, 398.
दोस्तों, माननीय सुप्रीम कोर्ट में कपिल सिब्बल की इन तीखी दलीलों ने इस पूरे मामले को एक बेहद दिलचस्प मोड़ पर लाकर खड़ा कर दिया है, जहां एक तरफ उद्धव गुट ने पार्टी के संविधान और दल बदल कानून को अपना सबसे बड़ा हथियार बनाया है, वहीं अब गेंद देश की सबसे बड़ी अदालत माननीय सुप्रीम कोर्ट के पाले में है। आपको क्या लगता है, वरिष्ठ अधिवक्ता कपिल सिब्बल की इन तीखी तर्कों में कितना दम है? अपनी राय नीचे कमेंट्स बॉक्स में जरूर शेयर करें। जय हिंद दोस्तों।